When purchasing or selling real estate, I think you definitely need to have an attorney. If you're buying property, usually it's the biggest investment you're going to make in your lifetime. Or if you're selling property, hundreds of thousands of dollars are on the line here, and to not pay an attorney, $500 a legal fee to make sure all your T's are crossed, I's are dotted, is a little crazy to me. I think you definitely need an attorney. You want an attorney. They're going to be there to review the contract for you, to review the structural reports and findings, to review the title search, take care of the title insurance, and most importantly, they're going to be there at closing for you to make sure title is transferred properly. All the money's accounted for, going where it needs to go. I think you definitely need an attorney for a real estate transaction. An abstract is basically a 40-year history of the title to the property. Anything that's happened down at the clerk's office, title being transferred from owner to owner, any mortgages coming up, discharges of mortgages, again, a history, anything that's going on at the clerk's office will be in there, legal description of the property. Nowadays, really the abstracts are being replaced by title insurance, but I think they're important to have, and if you have it, you should hold on to it. If you ever go to sell your property, it could cut down on some of the search fees having that 40-year abstract. In a real estate transaction, you need title insurance because A, the bank requires it. If you're looking to get a loan, no bank's going to loan money to any buyer unless they buy the bank a title insurance policy. You also have the option of purchasing a title insurance policy for yourself, and I think it's a good idea to do so. Basically, title insurance protects the bank's interest and your interest against any title issues that could pop up post-closing. So when you go to a closing, a title search has been done. In theory, the buyer should be getting good, clean title, all judgments, liens, mortgages paid off. However, we know, there's always risk involved, and title insurance is going to protect your interest against anyone coming and saying they have an ownership interest in the property, or somebody coming and claiming they have a judgment or lien against your property. The title insurance will protect you. Tips that I have limiting liability for a buyer or seller in a real estate transaction is hiring a good attorney. I know one, but reviewing the contract, again, making sure that you know what you've entered into, what you're going to be obligated to do, very important. Also, there's contingencies in the contract. There's an attorney approval contingency that says even though you've signed the contract, after you've reviewed it with your attorney, you can back out, get your deposit back. There's the mortgage contingency that says if the buyer's gone to a couple different lending institutes and they've been denied a loan, they can show that to the seller's attorney and they're able to get their deposit back. If you do inspections and a major concern pops up, meaning the inspector thinks it's an issue on its own that could cost over $1,500, you can submit that and get your deposit back. So that's just a few ways of limiting liability in a real estate transaction. In the beginning of the process, the buyer usually would put down a deposit. I call it an earnest money deposit, usually $1,000 or so. And ways you can lose that deposit is by not fulfilling your obligations under the contract. There are ways you can get out of the contract, but if you're not fulfilling your obligations under the contract for no good reason, that's the way you're going to lose your deposit. So again, you can get out of a contract and get your deposit back by canceling under one of the contingencies. But if you decide you just no longer want to buy the property anymore, or you no longer want to sell, and you have no authority under the contract, that's a way you can lose your deposit. A seller is never obligated to make any repairs, regardless if they show up in an inspection or not. The distinction that needs to be made is if it's a major or minor concern. A major concern means the inspector said on its own that issue could cost over $1,500 to remedy. In that scenario, the seller, again, does not have to do anything, but the buyer can use that kind of as leverage, because if the seller refuses to make the repair or credit money, the buyer can back out of the deal. Where that is not the case when it's a minor concern. But regardless, major or minor, the seller is never obligated to make any repairs if they come up in the inspection report.